Hello, everybody. A very good afternoon to you all. My name is Kriti. So, in today's video, we'll be talking about the recent and the landmark pronouncement given by the Hon'ble Supreme Court on 11th of July 2022. So, the judgment that we are going to discuss today is the landmark case of Satender Kumar Antil versus Central Bureau of Investigation, which has been given by a two judges bench constituting of Honorable Mr. Justice M.M. Sundaresh and Honorable Mr. Justice Sanjay Kishan Kaul. So basically, the most important observation which the court had made with regard to the present judgment is that it has asked the center to introduce a specific bail act in order to streamline and simplify the law with regarding to the bail applications in India. This was done by the Honorable Supreme Court after referring to the similar laws in countries like United Kingdom, wherein the court observed that there is an eminent need to introduce similar bail laws in India also. Basically, in this case, the court had observed that in the landmark case of Siddharth versus State of UP, it was observed by the Honorable Court that the provisions of Section 170 of the CRPC has been wrongly applied and interpreted by the police officers and the investigating agencies, thereby causing arrests in a very routine and casual manner. So now let's see that what were the broad observations which the court had made in the present judgment. Basically, the court in the present judgment, after expressing its displeasure in the case of Siddharth versus State of UP, had analyzed that there is a need to lay down specific guidelines that must be borne in mind by the police officers and the investigating agencies while releasing the accused on bail. And basically, in this judgment, the court had underscored and underlined the principle of bail is the rule and jail is an exception, and the principle of presumption of innocence being the core elements of the criminal jurisprudence. Moving on to the observations, firstly, the court in this case had categorized all the offenses under the Indian Penal Code into four broad categories for the purpose of application of these guidelines. So, the categorization of the offenses was such that, firstly, the first category was category A, which includes the offenses which are punishable with an imprisonment of 7 years or less than 7 years. Secondly, there is category B, which includes the offenses which are punishable with either death or life imprisonment or for more than 7 years. And thirdly, there is category C, which includes the offenses which are specifically punishable under the special acts such as the UAPA, PMLA, or the NDPS Act, etc. And fourthly and lastly, there is the offenses which are punishable under the economic offenses, which are not lying specifically under the special acts. Further, the court for the application of these guidelines had laid down that there are certain preconditions that must be first satisfied for the application of this judgment, and thereby the court had laid down that the preconditions and the caveat is such that firstly, the accused was not arrested during the investigation, and secondly, the accused has cooperated throughout the investigation and made himself available before the police officer and the investigating agencies as and when required for the purpose of investigation. Now, moving on to the observations which the court had made in the present case. So, firstly, the court had reiterated the provisions of Section 41, 41A, and 60A of the Code, which pertains to the provisions of arrest. So, as we all know, under Section 41 of the CRPC, the various conditions and the circumstances for the arrest of the accused has been provided, and thereby it has been laid down that the police officer may arrest an accused without a warrant in a cognizable offense if a reasonable suspicion exists that a cognizable offense has been committed by him. So, as per the mandate of this provision, it has been provided that even in a cognizable offense, it is not mandatory for the police officer to make the arrest, since the term used in this section is may, which denotes that the police officer has a discretion to make the arrest or not. Secondly, the court had observed the provision of section 41A of the CRPC, wherein it has been provided that for the purpose of appearance of the accused in court, a notice can be issued by the police officer to such person if his arrest is not required as envisaged under the conditions in section 41 subsection 1 of the CRPC. Thirdly, the court also observed the provision of section 60A of the code, wherein it has been laid down that all the arrests by the police officer must be necessarily made in due compliance with the provisions of arrest as laid down under the code. Now, after reiterating these provisions, the court, with regard to these sections, referred to the landmark judgment of Arnesh Kumar versus State of Bihar, wherein in the year 2014, the Honorable Supreme Court had observed the scope and objective of these provisions and had laid down that for the purpose of making an arrest under these provisions, the police officer must have a reason to believe that an offense has been committed by the accused as envisaged under the conditions of Section 41 of the CRPC. So, while reiterating this case, the court in the present judgment observed that the element of reason to believe and satisfaction qua an arrest, which are present in section 41 of the CRPC, must coexist and must be mandatorily recorded by the police officers as compliance with section 41 and 41A of the CRPC. So, the court in the Satender Kumar Antil case observed that despite the element of reason to believe qua a police officer, the element of satisfaction qua an arrest has to be also present, and they must be mandatorily recorded, and both these elements should coexist while complying with the provisions of section 41 and 41A of the CRPC. However, the court in the Satender Kumar Antil case observed that despite the clear dictum laid down in the Anesh Kumar's judgment, the non-compliance of section 41 and 41A of the CRPC still prevails, and that the police officers are effecting arrests without due compliance of these provisions, and thereby they are causing arrest in a very routine and casual manner. So, the court, with regard to the present judgment, guided the lower courts to come down heavily on the police officers and the investigating agencies, those who are affecting arrest without due compliance of these provisions, and also said that any arrest which is made by the police officers in non-compliance of these provisions shall lead to an automatic release of the accused on bail. Thereafter, the court, with regard to these provisions, also guided the state governments and the union territories to facilitate standing orders in compliance with the provisions of section 41 and 41A of the CRPC. So, these were the broad observations which the court had made with regard to section 41, 41A, and 60A of the code, wherein the court said that as per the rationale and purpose of these provisions, it has been provided that the police officers cannot make an arrest while unreasonably curtailing the right to personal liberty of the accused as warranted under Article 21 of the Indian Constitution. And they also said that the arrests must be made by the police officers in the cases wherein it is absolutely necessary and the police officer has a reason to believe that the accused will abscond and not cooperate in the investigation. So, moving on to the next observation, which pertains to the provisions of section 87 and 88 of the code, which provides for the issuance of the summons and warrant for the appearance of the accused in court. So basically, with regard to these provisions, the court observed that for the purpose of appearance of a person in court, that appearance can only be ensured either through the issuance of a summon or through a warrant. And in CRPC, there can either be a bailable warrant or a non-bailable warrant. Now, with regard to the procedure for the issuance of summons and warrant, the court observed the landmark case of Inder Mohan Goswami versus State, wherein it has been provided that the procedure for the issuance of summons and warrant for the purpose of appearance of a person in court is such that in the first instance, the summons must be issued. In the second instance, the bailable warrants must be issued. And in the third and the final instance, the non-bailable warrants must be issued by the courts if the court in this instance is certain that the accused is trying to avoid the summons and is absconding from the trial before the court. So the court in the present case observed that in spite of the clear dictate of the Inder Mohan Goswami's judgment, the non-bailable warrants are issued by the courts as a matter of routine without due application of mind and without proper scrutiny of the facts of the case. So the court in the case observed that the issuance of non-bailable warrant results in the curtailment of the personal liberty of the accused, and thereby they must be issued in the most exceptional circumstances. And if the courts are compelled to issue a non-bailable warrants, they must provide a reasoned order for doing so. Further, with regard to these provisions, the court observed that there are certain circumstances which the courts can consider while issuing the non-bailable warrants, that is, when the issuance of the summons or the bailable warrants will not produce the desired result. And the court noted that the certain circumstances wherein the courts can issue the non-bailable warrants is that wherein the person is not available for the purpose of investigation, or that the person is trying to abscond for the purpose of investigation. Secondly, wherein the police authorities are not able to find the person for issuance of summons. And thirdly, where there is an immediate harm to someone from such person and there is an immediate need to place this person under custody. So, these are some of the circumstances and instances wherein the non bailable warrants can be issued by the court. And the court, in the present case, observed that the issuance of non bailable warrants results in the curtailment of the personal liberty of the accused, and thereby there can be no circumstances wherein the courts can be compelled to restrict the right of the accused as warranted under Article 21 of the Indian Constitution. So, thus, it directed the lower courts to keep in mind that when the non bailable warrants are issued, thereby the courts must record the reasons in writing for not issuing the summons in favor of the rights of the accused. Moving on to the next observation, which pertains to section 167, subsection 2 of the CRPC. So, with regard to section 167, subsection 2 of the CRPC, the court commented that this provision pertains to be another limb of Article 21 of the Indian Constitution, which has the principle of presumption of innocence being inbuilt in it. Basically, as per the mandate of this provision, the courts and the police officers are mandated to complete the investigation within a prescribed time limit beyond which they cannot detain the accused for the purpose of investigation. Basically, in section 167, it has been provided that what shall be the course that the police officer must follow if the investigation cannot be completed within 24 hours of arrest. And therein, it has been provided that if the investigating officer is not able to complete the investigation within 24 hours of arrest, then he shall present such an accused to the nearest magistrate within these 24 hours of arrest, and the purpose of this provision is to provide a safeguard to the accused upon such an arrest, and also to enable the police officer to obtain the further custody of the accused for the purpose of further investigation, or to leave the accused to the discretion of the magistrate if no such further custody is required. Now, with regard to this provision, the court in the present judgment observed various cases and precedents wherein the rights of the accused under arrest has been protected, and thereby the court, after analyzing these judgment, observed that in the matters of detention of the accused, the courts cannot be formal and technical. And the court also said that in the cases of ambiguity of the interpretation of the rights of the accused, the lower courts must always favor an interpretation which protects the rights of the accused who is under arrest rather than the technicalities of the state machinery. Besides this, the court reiterated the important provision of section 170 of the CRPC. So, while discussing this provision, the court referred to the recent and the landmark judgment of Siddharth versus State of UP, which was given in the year 2022 by the Honorable Supreme Court, wherein the Honorable Supreme Court has finally settled down the law with regard to the interpretation of Section 170 of the CRPC, and has said that the arrest is not a precondition for the production of charge sheet under Section 170 of the CRPC. Basically, the judgment of Siddharth versus State of UP has been given by a two judges bench constituting of Honorable Mr. Justice Sanjay Kishan Kaul and Honorable Mr. Justice Rishikesh Roy, wherein they have laid down and observed that the word custody used in section 170 of the CRPC does not contemplate either police custody or judicial custody, and it pertains to the production of accused for the purpose of charge sheet before the magistrate. So the court in the present case highlighted that as per the observations of Siddharth versus State of UP, the criminal courts cannot compel the police officers to arrest the accused merely for the purpose of production of charge sheet, and that it is not a precondition for the presentation of charge sheet before the accused, and also said that the lower courts cannot ask the police officers to necessarily arrest the accused merely for the production of charge sheet under section 170 of the CRPC. So the court noted that such an interpretation is beyond the scope and intent of section 170 of the CRPC, and also remarked that in the cases of section 170, an endeavor should always be made by the courts in protecting the rights of the accused, and thereby they must distinguish between the power of the courts to make the arrest and the justification for the exercise to do it. So the courts said in the present case that where the police officer is certain that the accused will not abscond and has in fact cooperated throughout the investigation, thereby the police officers cannot be compelled to arrest the accused as envisaged under the provision of section 170 of the CRPC. Moving on to the next observation which the court had made in the present case, which relates to the provision of section 204 and 209 of the code, which relates to the issuance of process and the committal to the court of session wherein the offense has been exclusively tribal by such court. So the court in the case observed that with regard to these provisions, a discretion has been given to the magistrate to either remand the accused or to release him on bail. So, with regard to these provisions, the court observed that while exercising this discretion, the magistrates must act judiciously and with extreme care and caution, and thereby, while exercising this discretion, the magistrates can also take recourse to the provisions of Section 88 of the Code. Further observation which the court had made with regard to these provisions was that it has said that there is no need for separate bail applications under these provisions. However, if the magistrates decide to keep the accused in custody, then such magistrate has to give a reasoned order in writing for not releasing the person on bail. Moving on to the next provision, that is section 309 of the CRPC, which provides for the power of the court to postpone and adjourn the proceedings. Basically, in this provision, it has been provided that the courts are mandated to conduct the proceedings on a day-to-day basis until the completion of evidences. However, the court in the case of Satender Kumar Antil observed that the non-compliance of section 309 of the CRPC still prevails. And this is mainly because of the imposition of the monetary obligations as a bail condition in India, which requires the furnishment of the bail bond and of the sureties, which becomes difficult for the indigent sections of the society. Now, while reiterating these provisions, the court observed the landmark judgment of Hosenara Khatun versus State of Bihar, wherein Honorable Justice Bhagwati had observed the shortcomings of the bail system in India, which relates to imposition of the monetary obligations, and thereby has issued guidelines wherein suggested the lower courts to take into consideration other factors in spite of the monetary obligations, so that it becomes easier for the indigent sections of the society to take bails in India. Now, Justice Bhagwati, in the case of Husainera Khatun, had laid down certain guidelines and certain considerations which the courts can keep in mind while releasing the accused on bail, such as Justice Bhagwati had elaborated that the roots in the society or the status in the community or job security of the accused could be some other factors which the courts can consider while releasing the accused on bail, and these factors could be specifically considered by the courts in the cases wherein a poor person is involved or the accused has been punished for a less serious offense. Moreover, with regard to Section 309 of the CRPC, the court observed the landmark judgment of Menaka Gandhi versus Union of India, wherein it was observed by the Honorable Supreme Court that any procedure which causes an unreasonable delay in releasing the accused who is under incarceration cannot be called to be reasonable, fair, and just, and thereby it guided the legislator and the administrative authorities to change their approach towards pretrial detention and thereby ensure justice to the indigent sections of the society. So, with regard to Section 309 of the CRPC, the Honorable Supreme Court guided the lower courts and said that an endeavor should always be made by them in complying with the provisions of Section 309 of the CRPC, and had said that any non compliance of this provision would release the accused on bail and it would be a valid ground for the accused to be released on bail on such conditions. Now, let's see the next observation which the court had made that pertains to Section 389 of the CRPC. So basically, Section 389 of the CRPC provides for the suspension of sentence, and therein it has been provided that the appellate court has a power to release the accused on bail pending the execution of the sentence against him if an appeal has been filed by such accused. So the appellate court has a discretion to suspend the execution of this sentence until the main appeal has been disposed against such an accused. Now, while reiterating this provision, the court said that all relevant factors such as the delay in taking up the main appeal or the revision, along with the benefits conferred under Section 436A of the Code, should be some factors which the courts ought to consider while releasing the accused on bail. After that, the court, with regard to Section 389, reiterated the case of Atul Tripathi versus State of Uttar Pradesh, wherein the Honorable Supreme Court had observed that the object of this stringent provision is to provide that the courts are appraised of all the relevant factors such as the manner in which the offense was committed, the gravity of the offense, or the age of the accused while granting the release to the accused under Section 389 of the CRPC. Further, in the case of Atul Tripathi, the court had observed that there is a distinction between the grant of bail under the provisions of Section 389 of the CRPC or that under Section 439 or 437 of the CRPC, since Section 389 provides for a post-conviction bail, and thereby, while granting the bail to the accused under Section 389, the provisions of bail is the rule and jail is an exception, and that of presumption of innocence of accused cannot be considered by the courts. However, the court laid down that there are certain factors which the court ought to consider while releasing the accused on bail under the provision of Section 389 of the CRPC. Thereafter, the court also referred to Section 436A of the Code, wherein the maximum period for the imprisonment of an accused in India has been provided, which lays down that no accused can be kept in custody for more than half of the maximum period prescribed for the offense. So, as per the mandate of Section 436A of the CRPC, it has been provided that the maximum period to detain a person in custody is more than one half of the maximum period prescribed for that offense. And while discussing this provision, the court reiterated and observed the case of Bhim Singh versus Union of India, wherein it was laid down that regular meetings must be held to ensure that the prisoners who have gone through an imprisonment for more than half of the period should be released by the courts, and thereby the intent of this provision is to ensure that there is a fast track process and there is justice ensured to the accused who is lying under incarceration in India. Now, the next provision which the court had reiterated was Section 437 of the court, wherein the Honorable Supreme Court in Satender Kumar Antil case had observed that the jurisdictional magistrate who otherwise has the jurisdiction and the power to try an offense which is punishable with either death or life imprisonment or for more than 10 years has got ample power and jurisdiction to release such an accused on bail also. Lastly, the court had observed with regard to provision 436, 437, 438, and 439 of the code that all these provisions must be read in consonance with each other, and the courts should consider the element of reasonableness of the bail amount and that of sureties. The last observation which the court had made was with reference to the role of criminal courts, and the Honorable Supreme Court had made a remark that the criminal courts are the guardian angels of the liberty of the accused, and thereby they are duty bound to protect and preserve the rights of the accused under incarceration, and also to protect the constitutional values and ethos as warranted the Article 21 of the Indian Constitution. So now, these were the broad observations which the court had made relating to the provisions of arrest and bail in India, and the court had reiterated the several provisions of the CRPC relating to the bail and arrest. Now, let's quickly review that what were the broad observations which the court had made in the present case. So, here is a list of a conclusion and a list of the broad observations which the court had made in the present judgment of Satender Kumar Antil versus Central Bureau of Investigation. So the first observation is that the court has asked the center to introduce a bail act in order to streamline and simplify the law with regarding to the bail applications in India. Secondly, the court had guided the lower courts to comply with the provisions of Section 41 and 41A of the Code, and also to comply with the directions issued in Anesh Kumar's judgment. Thirdly, the court had also guided the lower courts to comply with the direction in the case of Siddharth versus State of UP relating to the provisions of Section 170 of the CRPC, and therein it has been laid down that the arrest should not be made a precondition for the purpose of production of charge sheet under Section 170 of the CRPC, and wherein the courts are certain that the accused will not abscond and has cooperated in the investigation, thereby the police officers are not duty bound to make the arrest under Section 170. Fourthly, the court had observed that the bail applications are to be disposed within a period of 2 weeks. Fifthly, the court had said that the high courts are directed to undertake the exercise of finding out the under trial prisoners who are not able to comply with the bail conditions and thereby comply with the provisions of 436A of the CRPC. Sixthly, the court had guided the lower courts to keep into consideration the direction given in the Bhim Singh judgment, wherein the conduction of regular meetings in analyzing the prisoners who have gone through an imprisonment for more than half has to be analyzed. Thereafter, the court had said that there is no need for a separate bail application while considering the applications under Section 88, 170, 204, and 209 of the Code. And lastly, the important observation which the court had made was regarding to the mandate of Section 440 of the Code, wherein it has been laid down that the courts cannot insist on the furnishing of the sureties, and the court must keep the element of reasonableness while ascertaining the bail bond amount under Section 440 of the CRPC. Now, these were the broad observations which the court had made with regard to the present judgment. However, in this case, and recently on 21st March 2023, the Honorable Supreme Court had issued an order wherein, after expressing their displeasure, the court had observed that even after the express guidelines given in the Satender Kumar Antil's observation, the guidelines have not been necessarily complied with by the police officers and the investigating agencies. And thus, the Honorable Supreme Court recently has ordered the High Courts to supervise the district courts and to see that they are complying with the guidelines laid in the case of Satender Kumar Antil. So the court recently on 21st March 2023 had observed that even after 10 months of the judgment, the law laid down in Satender Kumar Antil has not been followed by the district courts and has guided the high courts to supervise the compliance of the guidelines given in this case. So, this is what the court had laid down broadly with regard to the observations in Satender Kumar Antil. And in the last, I would like to end by saying that this judgment has definitely gone a long way in protecting the rights of the accused under incarceration and in protecting the rights of the accused who has not been arrested during the investigation and has cooperated in the investigation. However, we would know better about the result and benefit of this judgment once the dust settles and this judgment has been expressly applied in both its letter and spirit by the administrative authorities and also by the legislature. Until then, this judgment is definitely a welcome step, and it shows the progressive approach of the Honorable Supreme Court in protecting the rights of the accused under incarceration. That is all from my side. I hope that I've been able to lay down the broad observations and this discussion had appeared to be fruitful for you. That's all. Thank you.